Here we go. All right, now we've started recording, just so everyone knows that. My name is Ava Ayers. I'm the director of the Government Law Center at Albany Law School, and I'm very happy to welcome you to this program, which is sponsored and made possible by the Community Foundation of Herkimer and Oneida counties, to whom we're very grateful. So today we're going to be talking about insurance and how businesses can adapt to the needs created by the COVID-19 crisis. Before we get started with the program and I introduce the speaker, I want to let everyone on the call know that the Government Law Center will be arranging individual consultations for folks in Herkimer and Oneida counties who have small businesses and who need brief legal advice. We'll be following up with everybody on the call to let you know details on that. But if you or someone you know could benefit from those services, please don't hesitate to reach out. And again, we'll be following up after this event with those who are on the call. So you don't need to worry about writing anything down at this point. So with that, I also want to say thanks to Richard Rifkin, the legal director of the Government Law Center, who arranged this panel and made it possible. And with that, let me introduce our speaker for today. So Richard Liskov is an attorney with Arent Fox. Before he went into private practice, he was the deputy superintendent and general counsel for the New York State Insurance Department. He now practices insurance-related transactional and regulatory law. So in short, he's an extremely knowledgeable expert on insurance. He is now both an adjunct professor at Albany Law School. He also teaches U.S. insurance regulation at Boston University Law School through their online graduate program. Please forgive my dog, who's understandably excited by today's program. So with that, let me introduce Rich, and let me just say we are going to be taking questions both through the chat, and if you know how to raise your hand virtually, feel free to do that. I'll be asking everyone to wait until after Richard's presentation, which we expect to take about half an hour, and then we'll have plenty of time for questions. So with that, Rich, thank you so much for being with us today.
Thank you, Ava. Let me share the screen and start the slideshow. Here we go. My computer is a little slow, but should get there. Okay. I want to talk with you today and appreciate the opportunity to do this through the Albany Law School Government Law Center about coping with COVID and insurance issues. And I am not acting as your attorney when I give you this presentation. I'm not acting as an attorney for anyone. All of the statements I make and all of the positions I espouse are my personal views. And these statements and positions do not purport to represent, should not be considered as the statements and positions of any law firm with which I have been affiliated, or of any attorney at such firm, or of any client of such firm. So, as small business owners, you are probably familiar with various types of insurance that you already have, including property, which may have additional coverage for business interruption. You may have commercial general liability insurance. You may have workers' compensation insurance for your employees. In fact, the law requires that if you have any employees who do any manual labor, you are required to have such insurance, even if you're a not-for-profit organization. And you may also have health coverage for your employees. each of these types of insurance has been affected by the COVID pandemic. So let's start with how COVID has affected property and liability coverage in New York. And let me start with the area that I'm most familiar with, which is regulatory developments. The New York State Department of Financial Services issued an emergency regulation in force between March 30th and July 6th, which prohibited cancellation, non-renewal, or conditional renewal of a property or liability policy for 60 days for non-payment of premium if the policyholder was a small business suffering financial hardship due to COVID. And a small business was defined in that emergency regulation as a business that had a New York place of business, having fewer than 100 employees, was independently owned, not a subsidiary or an affiliate of a parent company, and which had submitted a written attestation under penalty of perjury that it was suffering financial hardship due to COVID. The regulation did not require any further proof, just the attestation under penalty of perjury alone would suffice. The emergency regulation required property and casualty insurers and brokers and agents to notify New York policy holders by April 8th of their right to have coverage extended for 60 days, even if no premium were paid, and to have their premiums deferred and paid over a period of 12 months if they qualified as a covered small business. The regulation prohibited premium finance agencies from invoking their power of attorney to cancel a policy of a qualified small business for non-payment of premium for 60 days. If your business met the specified criteria for deferred treatment and you did not receive such a notice from your insurance company or your agent or broker, or if your insurance company or premium finance agency did not honor your request for premium deferral after you submitted the required attestation, you should file a complaint containing specific facts with the Department of Financial Services. And there is the link to file a complaint. As you would expect, there has been a spate of litigation around the country, over 1,200 cases so far, involving a kind of property insurance known as business interruption coverage. And these cases have been brought against insurance companies seeking a declaration that the insurance company is required to pay out on the business interruption part of the policy for any business that had to close or had its hours restricted by virtue of an executive order from the governor or other governmental mandate. The University of Pennsylvania Law School has tracked these cases, and you can check on the status of them at the link provided. Insurance companies have almost always resisted paying on these claims on two specific grounds. First, they argue that business interruption coverage requires proof of physical damage to the property, and that the COVID-19 pandemic does not cause physical damage. The other ground for denying coverage is that there is a specific exclusion in the policy for known viruses, pandemics, or infectious diseases. And because there have been so many policies issued with these various specific exclusions, over 135 cases that were brought initially against insurance companies seeking business interruption coverage have been voluntarily withdrawn by plaintiffs. They did not even progress to the answer or motion to dismiss stage. There has been relatively few cases brought in New York. And that is because New York has, over the years, gained a reputation as being a relatively policyholder unfriendly state, one that does not, in which courts do not routinely go out of their way to find for policyholders, even though courts do apply general principles of contract construction, which means that they look to see what the plain meaning of the contract is, and they hold any ambiguities in the insurance policy against the insurance company that drafted the policy. But they don't employ a doctrine used in some state courts known as the reasonable expectation of the policyholder doctrine, which essentially means that the policyholder wins if it had a reasonable expectation that there would be coverage based on the language of the policy. That is a looser, more policyholder friendly standard. New York courts don't use it. And for that reason, there have been a lot of cases brought in Florida, Missouri, North Carolina, states that have been known to favor policyholders in coverage litigation. But New York is somewhat unfriendly relative to other states. That's the reason why there have not been that many cases brought in New York. The cases that have been brought around the country, about 70% of them that have been decided by at least one court, usually the trial level court, have gone in the favor of insurance companies. They have rejected complaints by policyholders, usually on the ground that the policyholder did not prove there was physical damage to the property, but in some cases the courts invoke the specific exclusion in the policy for known viruses or pandemics or infectious diseases. Notwithstanding the reputation of New York courts as not being particularly friendly to policyholders, there have been cases brought, including a noted one that was brought in August as a class action on behalf of a number of well-known New York restaurants. The Business Insurance trade publication had an article in August about that case. The restaurants made a rather interesting argument for showing physical damage, which is that they had to rearrange their entrances, exits, interior spaces in order to comply with social distancing mandates. And that amounted to direct physical damage caused by the governmental order. And therefore, the business interruption coverage of their respective policies was triggered. That's their argument. They apparently, these restaurants apparently had policies that did not contain the specific exclusion for pandemics or known viruses or infectious diseases. And they were labeled, these policies were labeled as all risk policies, which gives these plaintiffs a little bit added force to their argument. So far, there has not been a decision on this class action that was filed just in August of this year. But there has been one decision from a federal court in New York, in Manhattan, the Southern District. The court denied a preliminary injunction directing the insurer to pay, and the judge in that case told the plaintiff's counsel, quote, "I feel bad for your client. I feel bad for every small business that is having difficulties during this period of time. But New York law is clear that this kind of business interruption needs some damage to the property to prohibit you from going. You get an A for effort. You get a gold star for creativity, but this is not what's covered under these insurance policies," unquote. And in so ruling, the federal district court was applying a well-established precedent from New York state courts, including the appellate division in the Roundabout Theater case, that holds that direct physical damage is a requirement for obtaining coverage under a business interruption part of the property insurance policy. The New York Department of Financial Services has an FAQ webpage discussing business interruption coverage. Here is the link for it. And the department also has an FAQ page for an unrelated topic, but I just thought I would mention it to you small business business owners who are concerned about coverage for property damage caused by riots and civil commotion. And there is the link for that. So I just mentioned that. Now, some property insurance policies have business interruption coverage when civil authority orders prevent access to the insured property. And typically these clauses require actual physical damage also, either to the insured property or to nearby properties. But there have been some property insurance policies issued without an explicit reference to direct physical damage in a civil authority clause. And if you happen to have a policy that does not explicitly reference direct physical damage to the property in your business interruption clause, that is definitely worth discussing with counsel as to whether or not you ought to be bringing a suit against your insurance company. My firm put out a client alert, and you're welcome to read it on this particular issue. So if you have a property insurance policy that covers business interruption, it might say business income. That's also used as the label for this kind of coverage. And you are considering whether to make a claim or bring suit on a claim that you've already presented to the insurance company, here are my tips for you to consider. The first is the obvious one. You want to make sure that you have the complete policy, including every single endorsement, every single rider, every single piece of correspondence about the policy, every single email you may have received from the insurance company about the policy. You want to have the complete record. You want to contact the agent or broker who sold you that policy and ask that person to go over with you line by line the provisions that are relevant, including any deductibles, any co-pays, any required notice provisions. You and the insurance producer you're talking to should be looking to see if there is a specific exclusion for, quote, known virus, unquote, or communicable disease, or infectious diseases, or pandemics, or epidemics. And if there is such an exclusion, the likelihood that you will prevail in court against your insurance company is very, very, very low. Look to see if there is a civil authority clause that does not require proof of physical damage. Ask your broker or agent if the insurance company might be persuaded to settle a relatively small claim, a couple $1,000s, without litigation, because either the producer is one that the insurance company values highly in your particular geographic area, or that you are a valuable insured to the insurance company, paying lucrative premiums over the years. And if the company makes an ex gratia payment to you, it will get that money back in the premiums that you would be expected to pay over the years. Sometimes insurance companies have been known to make payments voluntarily to insureds, even though the likelihood that a court would order them to make a payment is low. You should ask the broker or agent what her or his experience has been in presenting similar claims to that insurance company over the years. If you decide, based on your and your broker or agent's analysis of the policy, that you have a viable claim potential, then you should make sure you have every single relevant document organized for your counsel to look at and analyze. And be prepared to hire an expert accountant who's going to quantify your lost business income, and be prepared to pay your counsel and the expert lots of money for a long time before you see a penny from the insurance company, who will be resisting your claim, fighting you in court for years, taking multiple appeals at your expense, because you'll be paying your lawyer and your accountant a lot of money while those appeals are pending. And maybe in 3 or 4 years, you might get a settlement offer. Unfortunately, that has been what I think is the reality of fighting insurance companies on these kinds of claims. And I thought I ought to mention the pitfalls to you in this presentation. It doesn't mean you can't win. It just means that you will be spending a lot of money in order to win. Now, recognizing the difficulties that plaintiffs have in obtaining coverage in court, there have been proposals made, including a bill in the New York State Assembly and in the New York State Senate, to require property insurance companies to pay business interruption claims of small businesses, notwithstanding that there are exclusions in the policy, and not for infectious diseases, and notwithstanding the requirement of direct physical damage. Assembly Bill A 10226B is an example of a legislative proposal. There is a companion bill in the New York State Senate. Both of those bills have been referred to the respective insurance committees in the Assembly and the Senate. They have not progressed. They have not come out of committee. It is not known whether they will ever get to the floor of either the House, Assembly or the Senate. The Insurance Law Committee of the New York City Bar Association in June issued a report on the legislation without taking a position on whether the legislation should pass. The report notes that there are significant constitutional issues raised by these bills, as well as certain drafting problems with the bill. Um, and I had a hand in drafting that report. Now, Congress is considering legislation that would require business interruption coverage to be paid by insurance companies, with the federal government essentially acting as the reinsurer of those insurance companies and paying those insurance companies for a specified percentage of what they pay out. Though the Pandemic Risk Insurance Act is modeled after the same kind of procedure that was used in 2002 following the 9/11 attacks in order to allow businesses to obtain coverage for terrorist incidents. The federal government acts as the ultimate reinsurer of insurance companies that are required to offer terrorism risk coverage. Well, HR 7011, introduced in the current Congress, it uses the same model, but for business interruption coverage, with the federal government acting as the reinsurer of last resort. That bill has been referred to the House Financial Services Committee. No action has been taken on it. Now let's talk about liability and coverage in New York. And one development that I want to mention right up front is occurring as we speak, which is that in Congress, House and Senate negotiators are considering a liability shield to be part of the next COVID relief bill, which is expected to be enacted before the end of the year. And there is quite a bit of contentious debate right now occurring by senators and congressmen and representatives as to the contours of the liability shield. How will it be drafted? And the only thing I can tell you is stay tuned and stay up to date on developments in Congress about a liability shield for businesses, which would obviate the need for you to make a claim under insurance policies, depending upon when that liability shield took effect. It might be retroactive, it might be purely prospective. You'll have to see how the ultimate provision is drafted, and the advice I could give you on that is before you consult counsel, you want to get as complete and accurate a description of the provision. The Wall Street Journal would be a good source, the New York Times, Washington Post. I would not rely on anything that I read on Twitter or Facebook about it. I would rely on well-respected newspapers to tell you, and then I would consult your counsel who would analyze the actual text of the bill and the committee reports, if any, that would accompany the bill to explain what the provision meant. But if for some reason there is no liability shield enacted by Congress that would protect you from a liability claim, your commercial general liability policy should cover a claim as long as you have given prompt notice to your insurance company. And often your agent or broker can act as a conduit for your claim. But keep in mind, New York has fairly strict rules about giving reasonably prompt notice to insurers. And you will want to ask your agent or broker if there is a specific exclusion in the policy for known viruses, pandemics, epidemics, communicable diseases, or infection diseases. If there is, your insurance company may send you a disclaimer letter, or it may send you what we call a reservation of rights letter, which says we will defend the claim, but we reserve our right not to pay a judgment or settlement if you are found to have been liable under an excluded cause in the policy. So that your agent or broker will explain to you what a reservation of rights letter is. There might be a force majeure or act of God or pollution exclusion in the policy, which also could complicate the defense of your claim. You will want to make sure you can prove to your insurer that you have complied with the governmental mandates, closure restrictions, mask requirements, social distancing rules, and washing requirements, etc. Because if a judge or a jury found that you were grossly negligent, indeed if you were reckless, and imposed punitive damages on you or your business, you should know that New York law strictly prohibits insurance companies from covering punitive damages. One more point about suing insurance companies on a property insurance claim. You want to make sure you retain experienced counsel who has litigated against major insurance companies for years and years. This is not the kind of lawsuit for which a rookie is usefully retained. You want someone with years and years of experience dealing with major insurance companies on coverage litigation. Again, sometimes an insurance company will make an ex gratia payment, Gratia, ex gratia payment, voluntarily in return for a complete release, even though the law favors their position. If they think your broker or agent is important enough to their business, or if they think you are an important enough insured. So in a liability claim, the insurance company almost always has the right under the policy to select defense counsel, but if they consider you an important enough insured, they may waive that right and allow you to select your own counsel to defend the liability claim. As long as the defense counsel is willing to accept the insurance company's payment rates and comply with their reporting requirements, etc. Every liability policy has a cooperation clause, which requires you as the policyholder to cooperate with the insurance company and its appointed defense counsel, making every relevant document available, making every knowledgeable witness available for both discovery, pretrial, and at trial, for depositions, for document production, etc. As a small business owner, you are required to have workers' compensation coverage. The New York State Workers' Compensation Board has not so far issued a regulation or directive making an employee's claim for workers' compensation benefits presumptively compensable as a workplace injury or illness, even if the employee cannot prove that she or he became infected at the workplace. California is a state which, by executive order of the governor, made COVID exposure presumptively compensable. New York has not yet done that. The Workers' Compensation Board in New York did issue an FAQ webpage for employees, indicating what kind of evidence they would need to present on a workers' comp claim based on COVID. It is likely that employees in the healthcare and transportation fields who can show that they faced a significantly elevated risk of exposure from COVID would likely prevail on their claims. But if you operate an office, your employees would face the hurdle of showing that they were infected at the workplace as opposed to being infected somewhere else with a ordinary disease of life. So courts have often held that employees who cannot show specifically that they faced a significantly elevated risk of exposure to a virus like hepatitis, like HIV or something else, those employees in cases litigated around the country have not been able to prevail on their workers' comp claim. If you do receive a claim from an employee, you are required to promptly notify your workers' compensation insurance company and provide relevant information and witnesses. There has been legislation introduced in the state legislature in New York to make COVID an occupational disease compensable for sick or deceased employees who work at any businesses deemed to provide essential services during the pandemic, including any retail facility workers and any workers who do any work outside the home during a period of closure of non-essential businesses. The Labor Committee in the House, in the Assembly and the Senate have these bills. There has not been any action taken on them. But it's possible that in the coming session, there may be action taken.
Rich, just want to give you the time warning you asked.
Yes, thank you. Coming towards the end here. On health insurance, if your employees are covered by a self-insured plan known as an ERISA plan, the Employee Retirement and Income Security Act. If you have an ERISA plan that does not involve coverage from an insurance company, then the New York State Department of Financial Services directives that I'll talk about in a second do not apply to you. But if you have purchased health insurance under group health policy from a licensed insurance company or an HMO or the Empire Blue Cross plan, then you should know that the department has issued various directives and regulation requiring that telehealth services rendered by an in-network provider must be covered without copays and deductibles at least through January 7th. That insurance companies are not permitted to charge deductibles and copays for COVID testing, although they can still charge copays and deductibles for COVID treatment. And for employees defined by the regulation as, quote, essential workers, unquote, who were working as of March 7th including retail workers at essential businesses like grocery stores and pharmacies and gas stations and hardware stores. No deductibles and copays can be imposed for in-network outpatient mental health services unless the deductible is part of what are known as high deductible plans authorized by the Internal Revenue Code. Be aware that you are still required to notify employees who no longer will qualify for group health coverage that they have certain rights under the COBRA federal law. That requirement is still in effect for any employee that leaves your employment. I want to thank my colleagues at Aaron Fox. I want to thank Alan Borst, president of Willie Borst, and Maria John and Fred Garson of the Insurance Law Committee of the New York City Bar Association for helping me prepare today's presentation. And I look forward to your questions.
All right, thank you so much, Rich. So we'll take questions now. Anybody on the presentation should feel free to submit questions in the chat or to raise your hand virtually. And why don't I get us started? So there's so much information to absorb here. There's so many different kinds of insurance. There's so many questions and potential crises in each area. If you had to pick sort of just one thing that a small business owner should be aware of or paying attention to, whether it's something really important or some common pitfall that people run into, what would you say?
I think the most important thing is to have a broker or agent in whom you have confidence and whom you trust to give you accurate information and to ask as many questions of that insurance producer as you can think of about the coverage that you have. And some brokers and agents are afraid to tell a client that they do not have coverage. You don't want to have that person as your broker or agent because that producer would be doing you a disservice if they are unable to accurately read an insurance policy that they sold you and are unable to accurately give you the information you need to know. So you need to find an insurance agent or broker in whom you have confidence, who will level with you candidly, accurately, honestly as to the scope of coverage. That's the most important thing. The other is to make sure you have the complete policy, whether it be your commercial general liability policy or your property insurance policy. And I would ask the broker or agent to set aside a half an hour of time to go over with you exactly what provisions in your property insurance policy and your liability insurance policy are going to be affected by the COVID epidemic. So that I would do that even before you have a claim from an employee or from someone who visited your premises, and even before you think about making a claim of your own with the insurance company for business interruption coverage.
All right. Other questions?
Can I ask a question?
Please.
Sure, Richard.
With regard to, Richard's waiting for my question here. With regard to liability coverage,
Yes.
one, should you keep a record of all the steps you have taken, assuming the public can enter your facility, of everything you've done to try to protect against COVID in your establishment. And second,
Definitely.
and this is the really tough one for so many businesses, assuming you require a mask and somebody comes in and doesn't wear a mask, whatever happens, you ask them, is that a potential liability risk? Will the insurance company disclaim because you didn't enforce the mask requirement? What happens?
My sense, I don't know of any court decisions on that particular point yet. My sense is that an insurance company would want to know all of the facts to the best of the policyholder's ability to provide them, whether it be any video recording that was taken at the time, any contemporaneous notes or memoranda that were written at the time, any contact with law enforcement at the time to enforce the mask requirement. The insurance company is going to want to know exactly what happened in the interaction between the owner of the establishment or an employee of the establishment and a customer or invitee who refused to wear a mask. The insurance company is going to want to know how often the establishment allowed persons to transact business at the establishment without wearing a mask. If it is clear that the mask requirement was not enforced at all, then it is conceivable to me that the insurance company could issue a reservation of rights letter indicating that it reserved the right not to pay for a judgment if the policyholder were found to have been so reckless, so grossly negligent that allowing COVID to spread in the establishment. But until we get some court decisions on that very point, I don't think it's possible to be too definitive as to what the legal consequence would be to the owner of the establishment with a liability policy if that owner were found to be negligent in allegedly allowing COVID to spread in the establishment.
All right.
I'm not sure. I'm not able to give you a better answer. But it may become a moot point if, at least for businesses that comply with whatever federal liability shield is enacted. I am certain that in order for there to be a liability shield as part of this upcoming legislation, that there will have to be some good faith efforts on the part of the business owner to comply with CDC or other governmental mandates. So at least for those business owners that have complied with the federal legislation, it's going to be very difficult for a plaintiff to recover from them based on the liability shield. We, of course, will have to see what the Congress actually enacts, but that at least for a lot of business owners, the liability shield is going to protect them from claims. With respect to business owners who do not comply with whatever the federal law sets as the standards for immunity, then insurance is going to play a role. And unfortunately, unlike the property insurance context where you've got lots of case law right now on business interruption coverage, I don't know of any cases on the issue of whether someone can get insurance, notwithstanding that they allowed somebody without a mask to do business at their establishment.
All right, we've probably got time for one or two more questions if anybody has them.
Well, I appreciate Ava and Richard the opportunity to give this presentation. I would just leave our audience with the point. The New York Department of Financial Services has useful information for small businesses. I urge you to look at their website, their FAQ pages on business interruption and civil commotion or riot coverage, particularly. I would urge you to contact your insurance agent or broker to go over the policy provisions with you in detail that might be implicated by COVID. And I would urge you to find experienced counsel who has a lot of experience litigating against insurance companies if you are in dispute with an insurance company on a claim.
All right, well, thank you so much. Thanks, Rich Liskov. Thanks, Richard Rifkin, for helping put this panel together. Thanks to the Community Foundation of Herkimer and Oneida counties for making it all possible. And if you're interested in direct consultations or you know somebody who might be, please let us know, but you'll all be receiving a follow-up email. And this program, which has been recorded, will also be available both on the Government Law Center's website and in DVD form at libraries in Herkimer and Oneida counties. So again, thanks everybody, and stay healthy out there.
Thank you. Bye-bye.
Bye-bye.
Thank you, Rich.